Hello everyone, this is Emmanuel from EBAN from Brussels. Today is a very shining day here, and thanks all of you for joining us for this webinar on how technology transfer and intellectual property rights can foster your company. We have two great hosts here, Tanya Scalia and Lucia Bonventre. Both of them are working at the Italian Space Agency. Tanya has project manager and innovation technology transfer, and Lucia Bonventre has lower and research fellow. So I will immediately give the stage to our great speakers. Tanya, I will stop sharing my screen and ready to listen your presentation. And please, for all of you that are attending, this webinar will be recorded and you can watch it later on and share on our Space Up YouTube channel. If you have questions, please write them on the chat and we will try to answer later the presentation. So, Tanya, the stage is yours. Here we go.
Yes, thank you. I will share my screen. Please tell me if you can see it. Can you see it?
Yes.
Okay.
Thanks, Tanya.
Thank you, Manuela, for your kind presentation. I'm Tanya Scalia, as Manuela said, and I'm working for technology transfer, for the Innovation Technology Transfer Unit in the Italian Space Agency. I don't want to be too boring, so I thought I will start with very practical examples of what can be considered a technology transfer in space. So, I don't know if you can see this image on the left. You have a picture of the Apostolic Vatican Library. And I'm sure many of you will be wondering, what has it got to do with space? Well, this library preserves over 180,000 manuscripts and over 1 million books, many of which are very precious and ancient materials. So they had a problem, an issue here. They wanted to start a digitization project of this very important cultural heritage. But many of these books are very precious. You can't take them out. There's only one sample written by hand by monks in the Middle Ages. So they had an issue here. They wanted to preserve the information, not only the information related to the image of the book, but a lot of information associated to the history, to who wrote it, to many other information related to this cultural project. So that's how space came into it, because this problem, even though it comes from a completely different sector, is quite common to what our astrophysicists and astronomers have when they want to share information on space, on the space exploration. And the scientific astronomical community is already confronted with this relevant problem of sharing a lot of information related to big data, let's say. This problem started in the 70s, and they came with a standard already in the 80s, and that's how space comes into the Vatican Library. The proposal was the use of the FITS standard. FITS stands for Flexible Image Transfer System. And those of you who are familiar with astronomical data know that this is a standard format used in space that allows saving data with characteristics of robustness, flexibility, and last but not least, also in the absence of payment of royalties or authorization for use, which is also a parameter that was taken into consideration. So here we don't want to really go into the technical details and so on. It was just a first example of how sometimes space can come into solving problems, practical problems in this case, simply by putting together around the table people that that come even from completely different worlds. In this case, we have the, as I said, the Apostolic Vatican Library, and on the other hand, we had the Italian National Astrophysics Institute and the International Astronautical Union, and also ESA, that supported the whole process and the project. This is a particular example, but I'd like to give you some other ideas on other examples that are completely different too. Here you can see a robot. This robot is called Robo Climber and weighs about 4 tons. It's a robot that was built to prevent landslides. I better clarify here, because when there are rocks to be monitored, you have specific and dedicated companies that are very experts, and that have very expert operators who have to carry on a very difficult job, like climbing vertical slopes, build the constructions to stabilize, the walls, which is also very risky activity. With this robot, we saved time and costs, because with only a few hours of installation, this robot was able to set up a scaffold that to preserve this rock wall that usually takes days, if not weeks, in critical conditions to be built. So again, where does space come into it? Well, the companies that were put together in this case were companies, an Italian company that is expert in drilling and and in building, civilian scaffolds like this one. On the other hand, we had the Space Application Services, which is a Belgian company that worked with our Italian end user in this case. This company was responsible for the control system. Their competence, their very specific competence came from, which was then reused and readapted in Robo Climber, came from the flexible automation and operation user station tool, which they had originally developed for a project in ESA. This project dealt with the development of the 3-kilo micro rover nanocot, which was dedicated to space exploration. And the algorithms that were used were, let's say, not exactly the same, but almost, that were reused in this example. Another example coming from a completely different world, again, is this one. We have a home, and I'd like to bring up the example of a startup that was incubated in the ESA Lazio activities, of which I'm going to say just a few words more in a few slides, in a couple of slides. This startup, Airgloss, which was, as I said, incubated in the Italian Business Incubation Center for the ESA BIC, developed and is now offering affordable air quality sensors for homes, schools, and other applications. The sensor is patented and acts like an electronic nose that is able to, identify patterns of odors and detect chemical signatures and compounds, and also create alerts to users to inform about the deterioration of the air quality or about the presence of pollutants. Also, in this case, the original application for this sensor was developed for the International Space Station. So, without the idea of being exhaustive, we saw 3 examples of very strange and different industrial worlds that came together in some way and made use of space. Some made use of technologies, but we also have other examples. Here you see the shape memory phone, which nowadays we all consider we're all very familiar with this application. Many of us, I'm sure, we're using straight memory pillows. I don't know how many of you are aware of the fact that this is one of the most successful spin-offs that was done by NASA. The NASA researchers originally developed this material to keep test pilots cushioned during their flights. Other uses that have become quite common of space are dealing with telemedicine. Now it is quite common in terms that in remote areas, it's not innovative or as it used to be, the use of telemedicine. Well, the first large-scale telemedicine exercise was carried out in 1988 after the earthquake disaster in Armenia. After an earthquake, quite often normal phone lines are not working anymore, and so the satellite links were used for the first time on a large scale. And then after this let's say infield test in the 90s, is also set up the first telemedicine test in space. Nowadays, as I said, there are lots of examples, especially in remote areas in Africa or in Australia, where we use telemedicine quite, let's say, normally. Another example of a common use in this case of space data is, of course, comes from our mobile phones, from our smartphones. I'm sure most of us have got one. And a long way has gone since the first GPS systems were launched in 1973 by US, but nowadays we use our navigation systems, and in particular many of our smartphones are now using Galileo, the European global navigation satellite system that provides much more detailed information on and detailed, accurate, and reliable information on positioning, which is in particular very useful in urban environments where narrow streets, tall buildings, buildings that are very near to one another can block also satellite signals, and so sometimes even the optical image is not as accurate. So, as I said, I don't want to be exhaustive, but the reason to show you these such different examples is to tell you that, as you can see, we have here used space, either in terms of what we call upstream, i.e. technologies that are developed to produce space applications. Or we also made use of space, space data, like it is the case for the GNSS. Regardless of what is the use of, if it's space data in the upstream area or in the downstream area, we can say that the European Space Agency, but in our case, the Italian Space Agency, supports the ESA Space Solution Program. It is a large program, and I won't bother you here with all the details of each part of it, but I recommend, and as we said with Emanuele at the beginning, we're going to share the presentation with all the links, and if you have doubts, then you can contact us. What I want the message I'd like to bring to you is that this program includes many aspects and can include the support to all these different projects, because we talk about business applications, we talk about business incubation, and we have also technology transfer. I'll go briefly through the three, let's say, these three legs of the program. The ESA Business Applications, in this case, it is an optional program. So as you can see from the slide, not all the European Space Agency countries are supporting this part of the program. Italy is supporting it through its ambassadors. You can see that other countries are supporting this program. This program is open for business that want to be dedicated to the improvement of our lives on Earth, especially offering services that make use of one or more space assets like human spaceflight, SATCOM, satellite navigation, Earth observation, and space weather. There is also the part of the program that deals, and I already mentioned this before, with the business incubation centers. Here you can see on the left the number, how widespread the network of ESA BITS is in Europe, because we have ESA supports 20 ESA BITS, one of which is in Italy, and hopefully there'll become more even in Italy. And the program started in 2003, and since then more than 600 startups were supported through this program. I'd like to take advantage of this presentation to also mention that the Copernicus incubation program that is, I think, still ongoing until the end. You can submit your proposal by the end of May. In this Copernicus incubation program, the interest is in supporting startups with specific use that make specific use of Copernicus, so of Earth observation data. But the applications can range in the most different environments. As we saw in our examples, we could go from the industry to the environmental protection to agriculture, forestry, health, transport. So there is no limit in terms of the areas that can be, the commercial areas that can be supported. Last but not least, you can see here a network of brokers that is part of the technology transfer, let's say, leg of the program. Nowadays, there are 16 brokers covering most of these member states. And what the brokers can do for you, they can support you in, especially in the in carrying out a demonstration for the technology transfer in terms of what we call spin-out, i.e. Transfer of a technology that was originally used or invented for space, and that this technology you want to bring it to a non-space sector. This is what we call a spin-out. The brokers can support you in these terms, either with a demonstrator project, or contributing in increasing your network, and or evaluating also what you can do with patents. Besides these, the brokers are also in charge for exploiting the ESA patent portfolio, because as you can imagine, thanks to the space programs, we have a lot of know-how that can be used in different sectors. Know-how that quite often becomes a patent. So at this point, I would leave the word up to Lucia, because she can give you more details on what it means to have a patent in this sector and how you can valorize your patent, or evaluate why you should have a patent if you've carried on a project in space.
Thank you, Tanya, for the floor. Good afternoon. This is the boring part of the session. I will focus on the main industrial property rights that a company should protect, so patents and trademarks, which are among the best tools to boost technology transfer operations. That means several advantages, such as getting a leg up on competitors in the market, avoiding unnecessary technology and scientific applications, dropping research and development costs, and reducing time to market. Well, patents protect inventions. In general, an invention may be defined as a new solution to a technical problem. The solution is the idea and it doesn't require a physical embodiment. However, there are things that cannot be patented, such as discoveries, scientific theories and mathematical methods, rules and methods for playing games or doing business, and procedures for surgical, therapeutic, or diagnostic treatment. In addition, the illegal inventions are clearly not patentable as well. Patents can be granted for inventions that are new. An invention is considered to be novel if it's not part of the state of the art. The state of the art comprises everything made available to the public by means of written and oral description, by use or in any other way before the date of filing of the patent application. Also, documents may be part of the state of the art, such as a journal article, a scientific publication, or a web page. In addition, it doesn't matter where the disclosure happened in the world, because there is no geographical restriction. In other words, if you used your invention in public, you will be prevented from patenting for lack of novelty. An invention shall be considered as involving an inventive step if, having regard to the state of the art, it's not obvious person skilled in the art. That means a virtual person taken as a reference, such as an expert or an ordinary practitioner. Well, we can distinguish two basic principles: first to file and first to invent. The principle of first to file establishes that the right to a patent belongs to the person whose application has the earliest date of filing. Italy and the other European member states adopted this principle. However, other states, such as Canada and the United States, adopted the principle first to invent, which establishes that the invention belongs to the person who first made the invention. In these states, you can disclose your invention before filing a patent application. Indeed, you have a grace period of 12 months to file your patent application after you have disclosed it. Clearly, you can't file the same patent application in Europe because the application will be rejected for lack of novelty. Well, a patent is valid in a single state. However, you may file your patent application in Italy, and you may decide that you want to protect your invention also somewhere else, for instance, in Germany. But what happens if someone else has already filed in Germany a patent application for the same invention after your Italian filing? The priority principle is the answer. For a patent application, the right of priority is 12 months. That means that you can make an invention, file a first patent application, for instance, here in Italy, disclose your invention, and within 12 months from the first filing, you can file a second patent application abroad in respect of the same invention, claiming the right of priority from the first filing. A patent shall be protected for a period of 20 years from the filing date. No further renewal is allowed. After 20 years, the invention can be freely used by everyone. Of course, patents are the most effective way of protecting inventions, but exclusive rights are granted in return for the investor's full disclosure of the technology to the public. Another effective way of obtaining protection, legal protection, is to keep the technology secret and to rely on what we refer to as trade secrets, to keep information confidential. The difficulty of this method is that once the good is on the market, it can be obviously dismantled, and the secrets can be learned merely by looking at it, and the trade secrets protection is lost. If you want to file a patent application, you have three possibilities. You can file a patent application in a single state. In Italy, there's the UIBM, Ufficio Italiano Brevetti Marchi, that examines your patent application and grants a patent valid at national level. At European level, there's the EPO, European Patent Office, that grants European patents valid in all member states of the European Union and in some other countries. And after the grant, the European patent must be validated in every single state you're interested in. However, it's not required a further exam because the patent has been already granted by the European Patent Office. At international level, there's the World Intellectual Property Organization, WIPO, that receives international applications filed under the PCT, Patent Cooperation Treaty, and gives a non-binding opinion about the patentability of the invention. At this stage, an international search is conducted aimed at discovering the relevant prior art, but no international patent is granted. Indeed, after the exam, the application splits up into several national or regional applications for further examinations. But what about trademarks? A trademark is a sign that distinguishes goods or services of a given enterprise from those of its competitors. A trademark may consist in a word, a logo, a number, a letter, a slogan, a sound, a color, and sometimes even a smell, which identifies the source of goods or services with which the trademark is used. It's worth noting that registration is generally based on the principle of specialty, consistent in the combination and specification of the selected signs and the goods or services to be branded. The consequence is that apparently similar or identical signs may coexist, provided that goods or services protected are dissimilar. The registration of a trademark confers the exclusive right to use it, preventing any third party from using it in case of identity of a trademark used for similar goods or services, in case of similarity of the trademark used for similar goods or services, if the owner can prove that there is a real risk of confusion, and in case of a reputed trademark used for similar or dissimilar goods or services. This last case offers a wider protection beyond the boundaries of the specialty principle in order to avoid unfair competition and counterfeiting of well-known trademarks. Let's think about Coca-Cola or Google trademarks. The exclusive right covers any use of the trademark, such as making, putting on the market, importing, exporting, or using goods or services protected by the trademark. There are basically three main characteristics for a trademark. It must be new, distinctive, and it shouldn't be deceptive. A trademark is new when no identical sign is validly registered or used before for the same goods or services. It shall have a distinctive character to distinguish goods or services from those of other competitors. We usually don't have descriptive trademarks because they are devoid of any distinctive character with regard to the same goods or services. So we can't use the trademark chair for chairs and the trademark apple for apples. On the other hand, the word apple might well serve as a trademark for bicycles since it has nothing to do with bicycles or computers. A trademark loses its distinctive character in case of its vulgarization. It happens when a trademark is perceived as generic, the generic name of the product, like Post-it, Scotch, Scottex, Rimmel, thus losing any exclusive right. And finally, a deceptive trademark is one that says that goods for which it's used have certain qualities when they really don't have. An example would be the trademark real leather for goods that are not made of genuine leather. Also, trademark is valid in a single state. The concept of priority also applies to trademarks, which can be first filed at national level and then extended abroad. For a trademark, the priority can be claimed within a period of 6 months from the first filing. Upon registration, a trademark shall be protected for a period of 10 years from the date of filing. one or more renewals are allowed for periods of 10 years from the filing date without any limitation, but the only one condition is the effective use. That means that if the the trademark has not been used for a continuous period of at least 5 years, and there are no proper reason for that, then the registration may be revoked. I just want to add that the registration is not the only way of protecting a trademark, because also unregistered trademarks are protected in some countries, like here in Italy, but it's a less reliable form of protection. This is because unregistered trademarks are not protected until they have a sufficient distinctiveness and a reputation in the marketplace, which can take considerable time. If you want to register a trademark, also here you have 3 possibilities: national, European, and international registration. A trademark can be registered in a state and then extended abroad, claiming the priority right from the first filing within 6 months. In Italy, there's the UIBM, Ufficio Italiano Brevetti e Marchi. A European trademark can be filed with the European Union Intellectual Property Office. The European trademark will be valid in all member states. And then the international registration requires a prior national registration. International application is administered by WIPO, but there's no international trademark valid worldwide. For countries that joined the particular system, Madrid system, including Italy, United States, Canada, China, Japan, and so on, it's possible to extend internationally the national trademark through the offices of WIPO, whereas for the other countries, it's necessary to file a single national application. So that's all. I don't know if you want to find more information. You can see some links in the following slides. And
yes, yes. I think Emanuele maybe will share this, because you can, among these links you will find all the details about also the example cases that I brought on before, and all the detailed information that Lucia has provided on patents.
Okay. Yes, sure. There are quite a few. I see. Okay, that I think will be quite useful for our attendees. I will start with the questions. And the first thing is, let's say I have a very good project. I have my company running, but I would like to, I don't know if there is a space technology that can help my business to improve. Who should be the person or the entity that I should reach?
Well, I would say that depending on the country where you are, because in case you're in Italy, of course, the Italian Space Agency and our office could be the good, and that's actually our daily job, our daily work. What Lucia and I, we try and support companies who have got these kind of ideas. But in general, I would say that the first step for you, even to take a look at what are the technologies that are offered within that come from the space sector, is the ESA Space Solutions website. There you will find also, as I said, the list of technologies that are managed by the brokers. So the brokers in each country take care of gathering the space technologies that could be of interest in other sectors. Of course, they carry out this job with the support of ESA and of the national agencies. These technologies are put together, let's say, in a sort of database that is shared with the ESA Space Solutions website.
So basically,
what happens there? If you are a company and you find there description of a technology that you say, gosh, that's it, I need this, because if I have this technology, I can solve my issue with that machine you're using or whatever. The first entry point in that case would be the broker for you, your broker in your country. He or she, the broker, knows where who has the ownership of that technology. So that opens different scenarios. That's why, as you can see, with Lucia, we kept it quite open, because this is what really happens. You might have only a very basic idea, and you might be interested in just in getting to know people who are very familiar with algorithms of a particular kind. The broker could be the first contact point to put you in contact with the company that has offered that kind of technology. In other cases, maybe the technology doesn't come from a company, but it could be a university that has maybe started the development, but it's a very low TRL. And so in that case, you might wonder and maybe decide to apply for a low TRL project, maybe on ESA itself or in other national programs. Or another case could be a patent. Maybe you find out that the patent that the technology you're looking for is a patent that belongs to ESA. In that case, you would be put in touch with the ESA referee or the clerk. And ESA, for example, has got a different strategy with patents in terms that being an agency supported by many countries. Usually, if you want to use that technology, their patent for the space sector, they can't guarantee the exclusiveness, but they give it for free. If it's instead not for the space sector, they still can't guarantee the exclusiveness, but there could be other kinds of solutions to support the company. So as you can see, there are
broad possibilities. So basically, I would say that the first suggestion for you will be, first, looking quickly at ESA Business Applications website, right?
Space Solutions, which includes also business applications.
And then, yes. And then reaching the broker, the local broker.
Because
and then they can redirect you in the best to the best or service. And is this service free of charge?
Yes, this is a very important and crucial question. You're right, and you should always point it out, because I was a broker myself in my previous activity, as you know, and sometimes companies get scared. No, this is the framework where this is all built, is that space costs a lot of money, and it builds up a lot of competencies, know-how, technologies that are quite often paid by governments. So you think about NASA, which started its technology transfer program in 1954. This gives you the idea of how already in the 50s they understood that space, there's also a communication problem here. I mean, space has the opportunity of supporting life on Earth, not only beyond Earth, which is also very interesting, of course. But the goal of these activities is to bring down on Earth, bring space down on Earth again. And so the agencies and the European Space Agency, with the support of the national agencies, do this support for free, in terms that the brokers are paid by the agency.
I see. Okay, this is good news.
Yes,
we have quite good services to improve our business. And now we had a question for Lucia about regarding intellectual property, more specifically for the patent. A person, Marcos, is asking that you say that basically if you reveal your project, your technology, you cannot patent it. But he has asking more clarification. He is saying if you publicly talk about the technology concept, so you don't steal that a product for promotional or fundraising purposes, you cannot
Yes.
patent anymore.
Yes, exactly. Novelty is an essential requirement for a patent claim to be patentable. As I said, an invention is not new and therefore not patentable if it was known to the public before. So if you want to patent, keep your invention secret until the filing application.
Yeah, but for example, you have, let's say, oh, I want to develop a flying car and please fund my project. I'm not revealing the technology behind it. I'm just saying I have
Yes,
a
of
flying
course,
car. Yeah.
of course you can you can't disclose the technical parts of the invention. Of course, I'm talking about the specifics of your invention.
Okay.
Um,
Okay. I see. So probably.
but for example, in my activity during my job, it happened more than in some different cases that a very good invention couldn't be patented because of publication in literature or somewhere else. So
If I share my information via email, I'm not revealing in public, right?
yes, but it only takes one person, because this person can spread your information. You only have the possibility to sign an NDA, non-disclosure agreement, if you want to talk about your invention with someone else.
Okay, so as I understand, hopefully we are answering clearly for Marcus. So in the worst case, Marcus, please feel free to reach a lawyer, a local lawyer in your country. So you can explain a little bit what you are planning to do, the project in a broad, open way, but without revealing the technology, you can. As soon as you go explain, okay, this is what we are planning to do, the technology behind it, in that case, the patent could be not possible. But probably, Marcus, is better. I think if, Marcus, you're planning to do a crowdfunding campaign, I'm sure your and the platform provide this kind of support, explaining you how much or what you can reveal. What do you think, Lucia?
Yes, you can manage, you can explain your solution, but you don't have to be technical and specific. But you can, of course, you can publicize your invention in all platforms or database or wherever you want. The point is that you don't have to be specific, and you don't have to disclose the technical and the specialties of the invention.
I see. Okay, thanks, Lucia. Now a question from Timothy. He has his, I'm not familiar with the topic. Hopefully you know it. What is the role of freedom to operate analysis? How much should a software as a service startup worry about it?
Of course, the freedom to operate is part of the priority art research analysis. So it's the phase after the filing the filing application. I mean that once you submitted your patent application, your invention, and so your application will be examined by one or more patent offices. So in that phase, the offices will make a sort of examination about the state of the art, so about what exists in the scientific or technical field. And if they find out something that is already exists, of course you can't patent your invention. This is the part of freedom to operate, because you don't have freedom to operate, so to protect your patent.
Thanks. Good. Hopefully we got the everything is clear.
And to answer to the second question, the things that a startup have in general has to worry about is about the prior art. So before the first thing to do is to make an accurate prior art research. With there are many databases you can some of them are free, so you can just search freely.
In the EPO, is it also that you can also
yes.
find that kind of information? Okay.
Yes.
So maybe
also
the EPO website, the European Patent Office website will be the right place to start your research. Thanks, Lucia.
You're welcome.
Now we have Renee is asking, I think probably we already answered, but just repeat it. Basically, if she's saying that if you reveal the technology with a scientific publication, even if you are the publisher and the person interested to do the patent, you cannot do it later, after.
Yes, of course. Even if you are the same person to publish, it's the same, because novelty is an essential requirement. Okay. So if you disclose something about your invention, it's the same.
Okay, so you cannot.
You cannot.
You cannot. Okay. We are sorry. Please don't write anything. Don't reveal your technology. The idea probably, but not the technology. Now we have a question from Sayad. He's asking where is the website where he can find information about the brokers.
Please
show us maybe the yeah, sure.
I don't know if you can still see the screen. It is the third one, spacesolutions.esa.int.
Okay.
There you should have the links to the different parts of the program. So you have the business incubation and you have the technology transfer, and there you find the brokers for your country.
Okay, thanks. Sayad has another question, a little bit mysterious for me, but hopefully you can answer. How Madrid registration can help global market of the business? Is it?
Maybe I can try to answer. I think that he is talking about the Madrid system for the international registration of trademarks. Mm-hmm. It's an international system aimed at facilitating the registration of trademarks in several jurisdictions around the world. It's based on an agreement, an international agreement signed in 1989. I don't know, I can't remember. However, the Madrid system provides a system, a centrally administered system that helps you to gain an international trademark registration, but after that you need to gain a single national registration of your trademarks. It's a way to save some money in the registration process at the international level.
Okay, okay. So it's quite useful.
Yes.
Okay, good, good. And a question regarding, let's say you have a company with a great technology, and I understood, well, you're a lawyer at Italian Space Agency. Probably there are someone with your similar role in other national European agencies. And my question is, do you provide the support on writing patents and intellectual property, maybe for free or not for free, on charge, for any kind of company, or there are restrictions, requirements to receive your support?
Okay, yes, I give support on the patents related to our specific activities inside the agency. It also happened to give some advice to other companies outside the space sector, but however, space involved in space-related activities. However, there are two kinds of professionals. I mean, the patent attorneys and the patent agents that they usually help companies and private to write down a patent properly, because it's a very technical document.
Indeed.
You can't write it by yourself.
Indeed. And so I know there are the ESA business incubator centers. They do provide this help, support, or not even them?
Because yes, of course, they do.
Okay. So basically, if I have a company, maybe I should apply to be incubated in a business in an ESA BIC, and then there I can receive also that kind of support.
Yes, it's a part of the all the other services that they give.
Okay, perfect. So this is good news for the entrepreneurs. And do you have a suggestion of maybe I'm not a space tech company, or I'm not selected for an ESA business incubator center? What would be your suggestion to start? I have a patent. I want to start a patent, so for sure I need a lawyer, someone with experience. Should I start nationally, already European? Maybe wait a little bit because it's quite expensive, moreover.
Yes, it's a bit expensive, but I think that you need to protect your inventions. Generally speaking, you should start with a national application, and then you can extend. You have time, a bunch of time. You can wait. You have to wait the examiner's answer. After the national phase, you can extend abroad your application at the European, at least at European level, or at the international level. But the natural evolution is starting from the national country, and then study your market, your business, your market plans, and then protect in the countries that you're interested in.
Okay.
Not everywhere, of course.
And I see. We have a question from Peter asking, maybe you, Tanya, can help us on this. A company outside Italy with a tech project can apply to the Italian Business Incubator Center. Is that cross national participation? Now it's,
well, for what concerns the Business Incubation Center, you need to be in Italy, because, and I tell you quite clearly, sorry for the noise on the background, but the thing is the following: the business incubation centers get support from the national agencies, which translated into practice means that for Italy, the Italian Space Agency puts money to support each single startup, and the same applies in the other countries. So let's say the generation of business has to have an impact in the territory, because that's why we're funding this program, you see. So you can apply even if you're a foreigner, as long as the company is based in Italy. Then, if you apply to the Italian BIC, if you prefer, you can apply to the BIC in your country, because as I showed in the network before, there are more than 60 places, quite widespread in Europe. So also in this case, I would suggest that if you go on the ESA Space Solutions website, you will find not only the broker's contacts, but also the contacts for the ESA Incubation Center that is nearer to your place.
Okay, so maybe and the company, if they're willing to move, maybe they are German, they want to move to Italy, maybe they could also be.
Yes, as I said, as long as there's as long as they're based in Italy, then.
Okay, maybe they. Okay, and we have one of our partner from SME for Space, Roberto Giuliani. Maybe he
Roberto can answer, because he's a big owner. Owner. I mean, he's a big reference in Italy.
Okay, Roberto, if you want to say a few words.
Okay, not from SME for Space, rather than from Lazio Innova.
Sorry.
Thanks, Emanuele. Just to reply to this answer, each citizen that are part of the member states can apply in every ESA BIC in terms of application. Once the proposal succeeds in the next phase, it is required to establish an office, a branch office in the member state. For example, in our case, just because the financial scheme is in part financed by Italian Space Agency and in part from Lazio region government, the Ministry District of Regione Lazio, it is required that the company establish, at least for the incubation period, is operational headquarter in the frame of the incubator.
Okay, and then you also cover some cost for.
The costs are for the asset and for the research and development activities. I mean,
so the rent and travel are not cost covered.
No, just because the idea is to reinforce the asset of the young startup with the money that could be used, for example, for a new patent or for a new technology or for new know-how in technology transfer.
Okay, I see.
Thank you.
Thank you, Roberto.
Thanks, Roberto. Thank you, all of you. Basically, now we are 3 p.m. We are running out of time. Our webinar is going to finish. I would like to thank Tanya and Lucia for hosting this great webinar, Technology Transfer and IP Intellectual Properties. And well, if you have a question, please feel free to reach them. And thanks you again for waiting and for attending this great webinar. Thanks you.
Thank you. Bye.
Thank you. Bye.
Bye. Have a nice day.
Thank you. You too.
Bye.